Hello and welcome to the EDRM Global Webinar Channel. My name's Mary Mack. I'm the CEO and Chief Legal Technologist for EDRM. Today's webinar is an EDRM collaboration with our trusted partner, eDiscovery Today's Doug Austin, and it's called The Important eDiscovery Case Law Decisions for May 2023. Our faculty experts are Doug Austin, Tom O'Connor, and the Honorable Judge Andrew Peck. And we welcome your questions and feedback in the Counsel. This webinar will be recorded and available for replay at your convenience for the next quarter. You can download a certificate of attendance from the Counsel after the webinar to use for your continuing education requirements. Kaylee Wallstad, EDRM Chief Strategy Officer, is here with us today. What do we have for resources, Kaylee?
Thanks, Mary. I look forward to the Case Law Monthly Webinar Series so much. Thank you, Judge Peck, Tom O'Connor, Mary, and Doug. For resources, to the right of your screen, you'll see a paperclip. And if you click that, you'll see, don't miss getting your daily eDiscovery news. Be sure to subscribe to eDiscovery Today if you're not, with a link. And I think it was last month, but maybe in the pandemic, who knows? Doug with eDiscovery Today shared an awesome infographic, the 2023 Internet Minute. If you haven't seen it yet, you need to check it out. There is a link for that. And then Tom O'Connor dropped an awesome book, his latest, eDiscovery for the Rest of Us. There is a link to check it out and purchase. And then you can also learn more about how you can engage with Judge Peck. Check out the latest news on the DLA Piper site and see what Judge Peck has been up to. And then up next on EDRM's webinar channel, June 6th, a tech lawyer and an information scientist walk into a bar. They discuss ChatGPT, its promise, ethical considerations, and latest developments. That is June 6th with Ralph Losey and Dave Lewis of Redgrave Data. And that's a do not miss. And then you can save your seat for June's important eDiscovery case law, June 27th, and that will be on our brand new On24 platform, won't it, Mary?
It certainly will. It certainly will. Well, thanks, Kaylee. That's a lot of resources there. And Doug Austin, I'm going to introduce our speakers now. He's the founder and editor of our EDRM trusted partner, eDiscovery Today, and an established eDiscovery thought leader with over 30 years of experience providing eDiscovery best practices, legal technology consulting, and technical project management services to numerous commercial and governmental clients. Doug has published a daily blog since 2010 and has earned JD Super Awards 3 times. Tom O'Connor, and what can we say about Tom O'Connor that Mike Berman, our newest blogger, could have said better? Tom O'Connor is a national treasure. Oh, he has a wealth of litigation-related ESI experience. You know what's coming here. Helped run the prestigious Georgetown eDiscovery Academy, lectures on recent cases and developments in the law, and has published several books and blogs, and is a consultant. And Tom, hailing from the great city of New Orleans, is recovering from Jazz Fest. And he's stewarded the Gulf Coast Legal Technology Center for over 3 decades. The Honorable Judge Andrew Peck is a chambered rank senior counsel at DLA Piper, where he advises on copyright and trademark matters, also serves as a resource for the firm and its clients on litigation strategy and discovery issues from a judge's perspective. Judge Peck retired as a United States Magistrate Judge in the Southern District of New York after 23 years, writing many of our first eDiscovery opinions and later, of course, boilerplate objections. We cannot do them anymore. 502D orders, we must do them at all times, and technology-assisted review. Discretionary. And EDRM is grateful to all 3 gentlemen for serving on the EDRM Global Advisory Council. Doug, do we have cases today?
We do indeed, Mary. Welcome everybody to our day after Memorial Day eDiscovery Case Law webinar on the EDRM network. We have another set of very interesting and, based on this slide, verbosely described cases this month, including a dispute over sanctions for failing to preserve text messages for a stolen phone, waiver of privilege for inadvertently disclosed materials used in a deposition, disqualification sanctions for failing to notify of receipt of privileged materials, sanctions for conducting a deposition in bad faith after load file production confusion, ESI protocol requirements to conduct document review, and the scope of Slack and Teams conversations to produce around responsive messages. Just a reminder, we do welcome questions, and we'll try to get to as many as we can. And we will send out a copy of the slides after the presentation, so look for that too. Of course, any ideas expressed by us here today are our own, not those of our organization's clients or partners. Even ChatGPT knows that. Just ask it. And of course, before we get started with these cases, here's a quick note about the webinar format and sources of cases. This is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery today. We provide links to each of the stories about the cases, which in turn have a link to the actual case ruling, where you can check out the full ruling itself. These case law rulings are available courtesy of Kelly Twigger's eDiscovery Assistant site, which is a great resource not only for case law, but also for federal and state rules, checklists and forms, and a glossary of legal and eDiscovery terms. The eDiscovery Assistant has, missed it by that much, nearly 30,000 lifetime federal and state case law rulings, and they add as many as several hundred cases a month. eDiscovery Assistant is the definitive source for eDiscovery case law out there. So with that said, let's get into the cases. Our first case involved a wage and hours dispute under the Fair Labor Standards Act, where a central issue in the case was whether the plaintiff was employed as a line cook for a portion of his employment when he was first hired in May 2019 to entitle him to overtime pay for hours worked in excess of 40 hours per week during that time. The defendant sought text messages between the plaintiff and his supervisor, co-defendant Justine Zegna, but the plaintiff had his phone stolen, quote, sometime in July or August of 2022, unquote, after leaving it in his car unattended following a long work shift. He acknowledged that he had not backed up his phone prior to the theft and didn't have a copy of relevant text messages between him and Zegna, disputing the importance of those messages. Zegna had copies of text messages with the plaintiff starting in approximately December 2019, leaving an approximate 6-month gap in text messages from May 2019 to November 2019, which included the time that a plaintiff alleged he was employed as a line cook. The defendant sought bad faith sanctions over the spoliation of the text messages. While Maryland Magistrate Judge Mark Colson stated it was not reasonable to simply maintain those text messages only on his phone without at least verifying that they were being backed up to a cloud service or otherwise taking affirmative steps to create a copy, given the not uncommon occurrence of a phone getting damaged, lost, or stolen, he also stated, however, the court cannot conclude that defendants have carried their burden of showing prejudice of a type sufficient to warrant any discovery sanction, nor did he find intent to deprive. As a result, Judge Colson recommended that District Judge Julie Rubin deny defendant's motion for sanctions, finding that negligence in failing to take additional steps to preserve the missing text messages is insufficient to establish an intent to deprive. And that ruling was affirmed by District Judge Rubin about 10 or so days ago. So, Tom, are you surprised that the missing text messages couldn't be recovered from a cloud backup, since that's practically automatic these days?
Well, no, because practically automatic is not automatic, and there's a lot of gaps there. So if you have an Apple phone, if you're in the Apple world, that's pretty much automatic. I verified this with several Apple users who said they literally didn't have to do anything. But Apple has 57% of the cell phone market in the U.S. The next biggest is Samsung at 30%. And things are not so automatic in the Samsung world. They do have a Samsung cloud backup, and it can be set up to run. It depends on how it comes from whoever you got it from. And even then, the automatic backup only works if your screen is off, the phone is charging, and you're connected to Wi-Fi. So there's a lot of wiggle room for error there. And of course, neither of those possibilities talks about what if you've deleted files. If you've deleted some text files, they're not going to get backed up, although they might still be on your phone. So you need some technical prowess here. The other thing, real quickly, that was kind of a head scratcher to me here is the judge in the quote there. I think, yeah, it was in your second paragraph. It says that there was a 6-month gap in text messages from May 9, 2019 to November 2019. The case wasn't filed till September of 2021. So that kind of begs the question, was there a litigation hold letter? Were there negotiations or arguments going on? Was the person with the phone aware or reasonably aware that there was a likelihood of litigation? And the judge, in the opinion, further says that Zegna attests that from time to time she was made aware of this case. She was made aware of this case. She had worked with her attorneys on recovering all relevant text messages, end quote. I mean, it's not really clear to me that anything was missing from a time that it was required to be saved. Now that, of course, if we dove down deeper into the opinion, may not be the case, but just raised an interesting question in my mind.
Sure. No, that's great information and certainly a valid question. So let's take maybe a look at a little bit different angle here. Judge Peck, given that we've seen cases recently that involve sanctions for counsel, and that Judge Colson noted that plaintiff's counsel made a big deal about the importance of text messages, how much responsibility does plaintiff's counsel have in this situation?
Some, but not enough to make any difference in the result one way or the other. I mean, remember, this is a single plaintiff wage and hour case under the Fair Labor Standards Act. I had tons of those in front of me when I was still on the bench. And I would guess, although it never came up, that in most of those cases, it is just not worth it to plaintiff's counsel to take the time to back up their client's cell phone. Many of them do it, many do not. So, yeah, people who live in glass houses and all of that, if plaintiff's counsel knew that his client did not have all the text messages, it would have been dumb to be shouting about the defense text message lack or whatever it may have been that he was pointing to. But, I don't see any fault or any major fault on plaintiff's counsel here.
Okay. All right. So Mary, since Tom's kind of brought up the preservation aspect, and given the fact there was a crucial 6-month gap of messages that the defendant didn't have, what recommendations do you have for our audience regarding preservation of messages that may someday be relevant to litigation?
Well, we go right back to the left side of the EDRM to information governance and have the conversation about who owns the data. Is it going to be a BYOD, bring your own device situation? What state or country actually stores the data? And as Tom said, it wasn't clear to me either, Tom, if they had an obligation, a legal hold obligation at that time prior to the cell phone being stolen. So the other things that can be done are to consider a mobile data management platform. As Doug and Tom were talking about, syncing to cloud services, either iCloud, Google, AWS, Azure. And then you don't need to necessarily save everything. You can do date range preservation to and from particular people, search terms. You can use the packages like Celebrate, FTK, Mode 1 for more granular preservation. So there's all sorts of things that can be done if you think about them in advance. And I think that's the key. Think in advance.
Yeah, always good advice, and certainly I think hopefully the tools are making it easier, because that's certainly one of the things that keeps people from preservation is the difficulties of mobile devices, and it seems like some of the newer tools are making it easier to do that. So certainly a very interesting case, and we'll move on to the next one. And let's face it, everybody deserves a second chance, but 9 additional chances is something else. So this case, which was suggested by Judge Peck, the plaintiff alleged breach of contract and breach of good faith and fair dealing. And the court covered in detail, but also summarized nicely for bloggers, the plaintiff's failure to claw back privileged documents, including the 4 points you see on the slide here. There were 6 other points outlined in the case I didn't have room for on this slide because it was wordy enough. Essentially, the plaintiff disclosed privileged documents on February 24th of 2022, was notified of the disclosure of March 16th, but didn't take full steps to expressly assert privilege. Eventually, plaintiff's counsel allowed its witness to answer questions about the privileged emails in a deposition and never conferred with defendant's counsel or raised the issue with the court. And plaintiff's counsel didn't even object when defendant used the at-issue email, one of the at-issue emails, in its summary judgment briefing 181 days after the deposition. Given that history, Ohio Magistrate Judge Kimberly Jolson stated, plaintiff did not have a heavy burden to assert privilege, but still failed to meet it despite the opportunity to do so. Instead, counsel for plaintiff ignored 5 emails from defendant's counsel about the at-issue documents and allowed defendant's counsel to use the at-issue documents in 2 depositions. Summarizing, Judge Jolson stated, now plaintiff's counsel wants the court to claw back not only the at-issue emails, but the deposition testimony of 2 witnesses and defendant's summary judgment briefing. In other words, plaintiff wants the court to protect the sanctity of attorney-client communications, but it was plaintiff's obligation to treat the privilege like a crown jewel. Plaintiff continually failed to meet its obligations and as a result waived privilege. So Judge Jolson ruled that privilege was waived for the at-issue documents and their use in depositions and the use of 1 at-issue email in the summary judgment briefing, denying plaintiff's request to strike the at-issue email from the record. So Judge Peck, when you recommended this case, you said there are parts of the opinion you don't agree with. What would you have done differently in ruling on this case?
I mean, I agree with the result. Clearly, the amount of negligence or failure to assert the privilege did, in my view, result in a waiver. What troubles me is that Judge Jolson cited the IRTH decision for the proposition that under 502E, you have to show what you're doing to modify the provisions of 502B. Now, as you all know, and our regular listeners know, I am a huge believer in using a 502D non-waiver order, and one should use that in every case. 502E is like a limited purpose non-waiver agreement. It only applies between the parties to that case. It would not provide protection in a subsequent case. But to me, therefore, 502E is just like 502D. You don't have to say how you're modifying the 502B factors. So Earth was one of the first cases that I think misinterpreted 502E, perhaps because judges don't like you to protect against waiver, because that is different than the common law. You know, everybody's evidence, et cetera, et cetera. So that's the problem I had. And I do want to remind the audience that several months ago, several months ago means when we've done these for the last 2 years, it was there somewhere, when we looked at the Klein against Facebook case where the parties came to the court saying, we're having difficulty agreeing on what should be in our 502D non-waiver order, help us out. And one of the issues was use as opposed to disclosure. So what should happen if a privileged document is used in a deposition? And the court said, yeah, I could see that the lawyer might not be able on the spot to make that decision, but it can't go on forever. So you should put in your order that within 30 days after the deposition, you had to assert the clawback or it was waived. That's the sort of thing that would have helped here. But obviously the parties had not thought that all the way through.
No, they didn't. And certainly it was way after, before the plaintiff even tried to assert privilege appears. So that seemed to be a consideration as well in this case. So Mary, does the plaintiff have a case of malpractice against its own counsel for missing so many opportunities to claw back the privileged materials?
Well, I think if malpractice means anything, yes. This looks to me like attorney as potted plant. Like, so many opportunities to raise the privilege. It was, reminded by the opposition, sending him multiple letters, and even when the plaintiff's counsel emailed Chambers, asked the court to hold a discovery conference, this is in March of 2023, to address a privileged document inadvertently produced to defendant in discovery. The judge noted plaintiff's counsel did not ask the court to seal the findings that included the privileged document or citations to it in any of his email correspondence with the court. So just didn't treat privilege as privilege. So I think, yes, there's a good case.
All right. Certainly seems like it to me too. So Tom, Judge Jolson noted that counsel for plaintiff ignored 5 emails from defendant's counsel. Is there any logical explanation, or could there be any logical explanation for this, such as the emails being caught by the spam filter? Or does the fact that the documents were used in 2 depositions doom any argument the plaintiff could make regarding potentially missed emails?
Well, I suppose there could be some potentially logical or potted plant arguments, if you will, to explain it. But the counsel never raised any. It's not for us to say, well, maybe this happened or maybe that happened. I mean, they could have raised some sort of a defense to it. But I thought the judge's use of the word ignored was pointed. The person just, ignored it, didn't do anything with it. And I thought it was the use in the deposition may have doomed it. I'm not sure that was the complete doom, but I think the complete doom was, as you set up above there, the defendant used the issue emails in its summary judgment briefing, and the plaintiff did not object. So it wasn't just a deposition, it was pleadings. And the plaintiff just didn't respond. He ignored it. He ignored the constant use of it. I think that was deadly.
Sure. Question from the audience. If Judge Peck's Model 502D order had been entered in this case and the plaintiff not allowed the privileged emails to be used in a deposition and in summary judgment, but still engaged in all the other waiver conduct, then should waiver still result? The plaintiff's disregard for the defendant's notices in this case is pretty egregious. Judge Peck, your thoughts?
Yeah, it's a tough one. Ignoring, several, almost half a dozen times where the other side says, hey, this looks privileged to me. Come on. And getting no response is, bad facts make bad law. That probably alone, even under a pure 502D order, could be found to be a waiver. Period.
Yeah, well,
it's a head scratcher,
really. Yeah, so it was certainly egregious, as our listener pointed out. So with that, we'll move on to the next case. This was a wild one. To paraphrase the line from Cool Hand Luke, what we have here is a failure to communicate. The issue started when the plaintiff responded to defendant's Rule 34 request by producing approximately 7,000 pages of material in an electronic load file format so that they could be uploaded into Discovery Review software. Although the plaintiff produced load files, defendants did not upload the load files into Discovery Review software, so to defense counsel, plaintiff's production appeared to be a randomized or unorganized and duplicative mess. As Utah Magistrate Judge Jared Bennett stated, in referencing a particular book which presents a model that accurately describes how individuals, including civil litigators, go from observing a phenomenon to reacting to it as follows: see or hear an event, brain tells a story, feel an emotion from that story, take action. According to Judge Bennett, the action that defense counsel took was to make a record by taking the plaintiff president's deposition, where he made several argumentative statements and questions, asked questions without a good faith basis, and scrolled through Boulder Falcon's document production in roughly sequential order to prove the point that he had received a document dump. Ultimately, plaintiff's counsel concluded that defense counsel was taking the deposition in bad faith to unfairly cast VTech in a bad light, had an emotional reaction based on that belief, and eventually ended the deposition prematurely. And the ruling documents many of the questions asked by defense counsel in the deposition, as well as considerable back and forth between counsel during it. Somebody pointed out that my title for the slide is not matching the case, which is true. So I apologize for that. Summarizing the issue, Judge Bennett stated, sadly, it was not until Mr. Benevento ended the deposition that both sides learned the truth. Boulder Falcon had produced load files for Discovery Review software, and Mr. Cohen had chosen not to use Discovery Review software and therefore had only the raw images of the documents. The bottom line is that this entire saga could have easily been avoided had Mr. Cohen done what the federal rules of civil procedure and their local counterparts require in the face of a discovery problem. Meet and confer before resorting to the, oh yeah, I'll show you tactics of litigation. So he denied defendant's motion for sanctions and granted plaintiff's motion for a protective order in using the deposition previously taken, but did allow defendants to depose VTech for the 2 hours remaining in the 7-hour period allowed under Rule 30D1. So Mary, the production was provided in load file format ready for uploading into Discovery Review software, but defendant's counsel didn't seem to understand that. What, if anything, could be done to avoid misunderstandings like this?
Well, I think, the whole, oh yeah, I'll show you tactics of litigation and, getting yourself into a meet and confer would be a good thing. But even before that, to read the cooperation proclamation. And that the idea that, you play gotcha with all of your, the appointments or the production dates, the production formats and all of that. But within that meet and confer, organize it so that you can have a sample production file exchanged immediately following the meet and confer. It doesn't have to have evidence in it, but the format should be there so you can test it on how they'll be using it. That would have surfaced the fact that they weren't using software, and perhaps the production would have been done differently. But then also include the 502D, the clawback, and of course have a transmittal letter explaining what's on your disk or in the file that you've just FTP'd. And for important transfers, make sure that you have voice-to-voice contact with somebody has received it and was able to do something with it. Because if someone puts it on the shelf for 6 months to a year and then tells you the production's not good, then you've got a bit of a headache.
Yeah, absolutely. Comment from the audience: case example of Hanlon's razor. Never attribute to malice that which is adequately explained by stupidity, which we actually had cited in a case from Judge Johnson last year. So it's got legal precedent in our webinars to boot. So
I'd also, Doug, point out, on the head scratcher here, Rule 34. Read Rule 34. 34 says, the plaintiff can say what format it wants the document production in, and then the defendant has the ability to either say, yeah, sure, or no, I'm going to do it a different way.
Mm-hmm.
Had that process been carried out as the rule required, even before getting into the meet and confer that Mary was talking about, we probably would not have had this failure to communicate.
Sure. Yeah, understanding form of production to begin with would be certainly a step in the right direction here. So, yeah, absolutely. So, Tom, since defense counsel wasted most of its hours, deposition hours, on the plaintiff's president and failed to even pursue a meet and confer on the issue, does the defendant have a case of malpractice against its own counsel?
I'm not sure about that. I mean, harking back to Mary's attorney as potted plant reference, I'm not sure this individual raises to the potted plant level. He may be an outdoor vegetable garden plant instead. But Judge Peck was reading my mind on that one. What confuses me is the lack of communications between the parties. It wasn't just one-sided. What format did you ask for it in, and what was the response? I would have assumed a load file would have come with an email or a letter that said, here's your concordance load file with your documents in a TIFF format and accompanying text, to which the recipient, if he didn't understand what that was, instead of just loading up the TIFF files, would have said, what are you talking about? Mm-hmm. So what did they ask for? Was there a response? Where was that? And the production, and even in that format, wouldn't appear to be a randomized, unorganized, and duplicative mess. If it was, in fact, a load file with TIFFs, the TIFFs would have been in some sort of numerical order, usually by some sort of Bates or numbering sequence. So it's not really like a data dump. And then finally, as the judge said, it was not until after the deposition was ended that both sides learned that the load files hadn't been put into document review software. That seems kind of late in the game to be figuring that out, showing a really alarming lack of discussion between the parties, both sides, about what was going on here. So I totally agree with Judge Peck. Read the rule book, Shankopotamus.
Oh, there we go.
Right?
It's indeed wouldn't be a webinar without read the rule book, Shankopotamus, at least once from you, Tom.
That's right.
There we go. And actually, certainly the plaintiff shouldn't have assumed, even though we all know what happens when you assume that the defendant understood what they were getting. So certainly that's fair.
Very
point.
odd. Yeah, yep. Very odd.
Indeed. So, Judge Peck, given defense counsel's lack of technical knowledge and failure to pursue a meet and confer to address the perceived issues with the production, do you think Judge Bennett's sanctions were enough?
Yeah, I think so. First of all, plaintiff's counsel didn't help matters, both by failure to communicate that he was producing in load file format, by some of the colloquy at the deposition that was reported in the decision. It should have been very obvious early in the deposition of the defendant's failure to understand the form of production. But in any event, one, judges don't like to do sanctions on counsel if it can be avoided. Secondly, he did order both counsel to read the rules of professional conduct. I think that is a sanction. Mm-hmm. And, many insurance covered for lawyers, insurance require you to report whether you have been sanctioned, as do some applications for pro hoc vice and the like. So, both counsel may be doing a lot of explaining in the future based on this, what seems like almost a nothing sanction. It has repercussions.
Yep, indeed. For sure. So, yeah, very interesting and heated dispute. So we'll move on to our next case. And I've got I swapped the titles on these two slides, so the title's wrong on this one too. Clearly, I decided to switch the order of cases at the last minute.
Did you rely on ChatGPT?
That was a chat.
I know, right?
Right.
What am I doing
Oh,
here?
I don't know. The citations look okay.
Yeah, there we go. Yes, I can assure you they point to real cases, so they're good, and I will fix that in the slides when they go out. So this is our second case about inadvertently disclosed privilege info this month, with a different issue in play. In this contract dispute, the lawyer sent more than 1,000 pages of emails to the plaintiff's lawyer electronically, and production was accompanied by a notice stating privileged information had been redacted. When the plaintiff's lawyer moved for partial summary judgment, defense counsel reviewed plaintiff's summary judgment submissions and recognized that the email fragments associated with them were content that he had intended to redact, determining that the metadata associated with the redacted portions had not been removed from the documents produced. And it should be noted that the ruling wasn't explicit as to what was meant by the term metadata. As a result, the content of the blacked out text was discoverable upon performing a word search of the document. Oops. Defendant moved to disqualify plaintiff's counsel from the case, alleging her receipt and retention of privileged materials violated ethical and discovery court rules. Plaintiff's counsel denied any wrongdoing, providing various explanations for her conduct, including assertions that she did not understand metadata and that she'd received at least some of the information from a third party. She also argued that the emails were not privileged and that they revealed defendant had engaged in its own ethical violations by withholding information and making misstatements to the court. The Superior Court denied defendant's motion to disqualify plaintiff's counsel, finding some of plaintiff's counsel's explanations were suspicious, but crediting her assertion that she did not knowingly search through privileged material, also acknowledging that disqualification is an extraordinary remedy, imposed only in extremely rare circumstances. The court instead sanctioned her by ordering plaintiff's counsel to destroy the files, promised to banish the email excerpts from the court's decision-making, and instructed the parties to not mention the excerpts again, a decision for which defendants sought discretionary review. Finding that prejudice had not been shown, that while fault was shown, plaintiff's counsel's culpability was not as severe as claimed by L&W, plaintiff's counsel lacked the knowledge to engage in intentional misconduct, and the possibility of lesser sanctions existed, so it found the trial court did not abuse its discretion in its ruling. So, Tom, what do you think about the argument that plaintiff's counsel didn't understand metadata, so it wasn't clear to her she was viewing privileged materials? Do you buy it?
Well, yeah, again, given our potted plant discussions of the previous several cases, sure, I buy it. I mean, these cases are all, hey, whatever happened to the duty of technical competence? Is anybody even paying attention to that? Is it possible? Do I believe that they didn't understand metadata? Sure. Should it be possible? No. I mean, how do you get to this point where you're exchanging emails electronically, but you don't understand what metadata is? I'm going to go back to something we said earlier in one, just today, which is where's the meet and confer in a protocol that says what it is we're going to exchange? Where's the Rule 34 that talks about what format you want it in and the definitions of what you're looking for here and a response as to what you're going to get? I mean, if you talked about this stuff at a meeting before productions, then you wouldn't have these sorts of issues. And it's compounded by the fact that it doesn't seem clear to anybody, including the court, what metadata meant in the context of this case. Was it really metadata in the technical meaning of that word? So I just go back again to at least the meet and confer, and if not, some sort of a protocol that talks about what you're going to exchange with definitions in it.
Yeah, sure, absolutely. And I swear I did not set this up, but my next question was going to be to Judge Peck about a comment Craig Ball made on the blog post. And sure enough, he's made a couple of comments here. So this really was not planned or set up, I promise. It's just funny how it works that way. Craig, I'll throw them out here real quick. Craig says, don't you hate it when people toss off terms like metadata in the context of email without caring to define it with greater specificity than and data about data. Grr, what in this email is to term metadata and why? Good question. And then his second comment was, if lawyers in Washington State are to derive any useful guidance from this decision beyond inchoate apprehension, the how of this failure matters. Else anyone using review tools is at risk of possible disqualification and disapprobation. More, what should the producing counsel have done to obviate the risk? We need to know the cause to discern the remedy, not just be advised of an occult symptom. So that's a great lead into my question to you, Judge Peck, which is that obviously Craig's complaining that it wasn't clear from the ruling exactly what was meant by metadata in terms of where the redaction failures occurred, which limited its usefulness for lessons learned. So how much responsibility, if any, do judges have for providing technical details that can be useful lessons learned in cases like this?
Hey, I'm sorry to interrupt, but I have to ask real quick. Did Craig really say disapprobation?
He did.
Okay, so if we're going to define metadata, I think we got to make sure we have a thesaurus.
I'm still working on inchoate or inchoate, whatever that is. So. But
I'm sorry, Judge. Judge.
Fair question. So, Judge Peck, what are your thoughts?
It's nice when the judge has the technical ability and the time to, teach the bar at large. But the fact of the matter is, and particularly in many state court practices, the judges are much too busy keeping the trains running on time, keeping the cases moving, and just, writes enough of an opinion to tell the parties to the case what they did or what they have to do. You also want to be careful what you wish for, Craig, because, a judge giving technical advice may well be misinformation to the bar, because many judges, do not have the technical skills of a Tom O'Connor or a Craig Ball, et cetera, et cetera. But no, I think, the judge is there to rule on the instant case. If there is a broader lesson, great, but that's not a requirement.
Yep. Craig responds, sorry, next time I'll use ChatGPT to rewrite for a broader audience. Nicely played. All right. So, Mary, obviously we don't know the specifics of what exactly the metadata was here, but what recommendations do you have for our audience on how to ensure that redactions are applied everywhere possible within their productions?
Well, redactions are a really complex workflow and a really complex application to program. There's the text that's inside a document and it gets rendered on the screen. It also gets rendered possibly as a TIFF or a PDF, for ostensibly printing out. And so if the software elements don't use a common rendering routine, it is a recipe for redaction disasters. The other piece is if the redactions just lay on top, they're not actually burnt in, which means destroying the text underneath it. That's a thing that, if it's viewable by a few keystrokes, if settings are incorrect. So making sure that all of that is all right. And then you may redact what you see on the screen, and maybe it'll print out in the right way as a text, but the extracted text itself that gets indexed, if that's not taken care of at the same time. And then the actual load file, you check that, make sure it's not in there. And did you regenerate the index? You might be indexing based on the redacted information and still have a hit come up. So if the platform supports multiple redactions per item, say for multiple cases, multiple attorneys, more QC is necessary. And then if metadata, like a subject line, I think that's what they're talking about, is going to be used inside a privilege log, it's certainly important to double check, because that's where you'll have the richest information. And then don't forget about the parents and the children, the threads and the dupes. there's always a trumping order for QC in privilege, and that's why the most highly trained professionals work on the privilege logs, because it is so complicated.
Yeah, those are all great tips, Mary. Last thing I'll note about this case, which I noted in the comments and in the blog posts, is that the lawyer defense counsel used a tool called Doc Review Pad, which apparently is a review platform for the iPad. So I'm curious if there's something that could be gleaned from a test with that to maybe figure out what's going on. But certainly interesting. And one of the things that I've certainly seen before is you think you've got the redactions great on the image, but you don't have them on the of the rest of the underlying data, and you're still disclosing it. So I think this was, even though we don't have exactly where it was, it's good to keep that in mind, that it's not just the images you have to check. So we'll move on to our next case, which is our second case in a row involving a request to review a ruling, and our second suggested by Judge Peck this month. In this case involving consolidated cross-claims relating to breach of contract, the parties agreed to an ESI protocol, which provided, under a subsection titled "No Presumption of Responsiveness," that a party's obligation to conduct a reasonable search for documents in response to discovery requests shall be deemed to be satisfied by reviewing documents that are captured by utilizing the methodology provided for in this protocol, and that the fact that a document is captured by a search pursuant to this protocol does not mean that such document is responsive to a discovery request or otherwise relevant to this litigation, and parties may exclude such non-responsive documents from production. McCormick learned that despite the issuance of a litigation hold, custodial files for a key custodian and witness were deleted when she left McCormick's employment. So McCormick gathered additional ESI to compensate for the deletion, which resulted in a significant increase in the number of potentially relevant documents, 20,000 plus, which was approximately 30% of the 67,000 plus documents with families McCormick identified. The parties disagreed as to whether McCormick was required to take the time, see what I did there, to manually review these documents for relevance prior to production, or whether they could produce those documents without a document-by-document review. The magistrate judge found that manual document review was required and rejected McCormick's argument that the costs associated with such manual review, which McCormick estimated at $240,000 for a disputed amount of no more than $4 million, was not proportional to the case. Obviously, they objected to that ruling. Maryland District Judge James Bredar stated, under the clearly erroneous standard, the court is only required to determine whether the magistrate judge's findings are reasonable and supported by the evidence. Continuing, he stated, McCormick incorrectly states that the ESI protocol provides only that a producing party may take the opportunity to review documents that are captured utilizing the methodology provided for in this protocol. McCormick omits a crucial portion of the ESI protocol, which provides that a party's obligation to conduct a reasonable search for documents in response to discovery requests shall be deemed to be satisfied by reviewing documents that are captured by utilizing the methodology provided for in this protocol. He also rejected McCormick's proportionality argument, noting there appears to be a large volume of potentially responsive documents due to an error by McCormick whereby the documents of a key custodian were deleted despite a litigation hold. So, Judge Peck, should a party be forced to conduct a review if they don't want to do so per Sedona Principle 6, or does the language of an ESI protocol supersede Sedona Principle 6?
The language of an ESI protocol, particularly if it's so ordered by the court, pretty much supersedes everything. And it's why, as we've talked about in prior monthly decision reports, is be careful what you agree to and make sure what you agree to is, sufficient for the way you want to review documents. Moreover, Sedona Principle 6 is not authority for a document dump or producing documents without review. It merely says that the producing party is in the best position to determine what a reasonable way to search for and produce documents is. So here, I suppose the parties could have agreed to use search terms, and that whatever was hit by the search term would be produced. But that's not what they agreed to. They agreed to use search terms, but then talked about review of the search term hits. And the fact that a document hits on a search term doesn't mean it's relevant. We've seen this sort of dispute in many different ways. Some where a party says if it hits on a search term, it must be produced because it presumptively is responsive. Others where they've agreed to a review but don't specify how that review will be conducted. And one side thinks it's going to be a manual, eyes on every document review, and the other wants to use TAR. So ESI protocols just need to be drafted much more clearly if they're going to be relied upon.
Absolutely. So, Mary, do you think the judge, I think I know your answer to this, but do you think the judge would have been more sympathetic to McCormick if they hadn't failed to preserve data from the key custodian, or would it not have mattered given the language of the ESI protocol?
Oh, yeah. I think it mattered. Prior bad acts, I think, definitely color future decisions. But I think what Judge Peck said is really important, and to be very clear in the protocols, because I think if we said review right now without human review, I think most people would think it, a TAR review or keyword assisted, or somehow you're using technology to help you review. You're deduping, you're threading, you're doing all sorts of things. So, yeah, I think that the protocols need to be more clear as well.
Indeed. Well, so Tom, what recommendations do you have for our audience to make sure they agree to an ESI protocol that gives them the flexibility to address unexpected situations that may come up like this one?
Well, two things, and I totally agree with Judge Peck's comment. You got to remember the protocol is going to supersede everything, so you want to make sure that it encompasses all possibilities. So first of all, don't try to make it this grand proclamation of how all ESI in the world of eDiscovery should be treated. You're not Martin Luther nailing a manifesto to the courthouse door, right? You're trying to reach an agreement with the other side on what Mary just described. How are you going to exchange these documents? How are you going to search? How are you going to do this? What are you going to do? So tailor it to your case and your documents in your situation. But secondly, it's gotta be, it's not just specificity, it's flexibility. Incorporate the ability to discuss things when an issue comes up. Mary mentioned a moment ago in one of the other cases about a sampling. First thing I always do is say, send me a small amount of data. Don't send me all your data. Send us a little bit so we can try it and make sure it works and see if there's a problem, because then it's a small problem. And it's not a huge fiasco. But the other thing is, I always tell my clients, put a paragraph in there that says two things. One, if there's an issue with a particular set of documents or document types or a production, and we're having a problem with it, we're going to discuss it, even to the point of having a meet and confer, if necessary, before we go nuclear. Okay, let's try to work this out. And then I also include language that says that attitude, the necessity of having some sort of a meet and confer, or at least an informal discussion, will also come into play if something new arises that we didn't think about. It's not just a issue or a problem with what's being produced in the documents we agreed upon. What if something new happens? What if we come upon a treasure trove of ChatGPT messages? All right. What are we going to do with that? Let's have a meeting to talk that over before we, throw it in front of the court. And as the judge said, slow the train down. So try to get that flexibility built into your protocol, so that you're going to discuss these things when they come up.
Yep, absolutely. We've seen several cases now where people have been kind of bound by the explicit language of their ESI protocol. So
Yeah.
there's definitely great advice to give yourself some flexibility there. By the way, I can't believe none of you kind of recognize my pun there with time and McCormick, but I'm going to move on. So,
Because he
they
didn't
are-
spell, he didn't spell it for us.
Spicy.
Yeah, there we
Spicy.
go.
Right. It
Now
wasn't,
we're talking.
wasn't spicy enough for us, Doug. That's
Okay, that's true. All right, maybe I should have. Maybe I should have been a nutmeg. I don't know.
Should have
We'll
sprinkled it
move on.
around a little more. That's all.
There we go. That's it. Indeed. Our last case just happened a couple of weeks ago, and we liked it so much we expedited it into this month's webinar. In this breach of contract case regarding a new ERP software platform, the court issued an order requiring the parties to submit a joint status report regarding the status of discovery disputes. The parties submitted the report indicating that they'd resolved all outstanding issues except the dispute regarding defendant's production of Slack messages. After asking for all messages in a conversation with any responsive messages, the plaintiff had narrowed its position, requesting that for any Slack conversation containing 20 total messages or fewer, defendant be required to produce the entire conversation so long as the conversation contains at least one responsive message, and that for any Slack conversation containing more than 20 total messages, defendant be required to produce the 10 messages preceding and following any responsive message. The defendant objected, arguing that it had already reviewed all Slack messages that hit on any of the parties' agreed search terms, as well as the 10 messages before and after any message that hit on a search term, and produced any message in that window that provided context for the relevant discussion, and that adopting the plaintiff's proposal would impose an undue burden. Both parties offered an analogy to support their position. The defendant argued that because Slack messages are stored as individual JSON files, the plaintiff's proposal was the equivalent of requiring a party to produce irrelevant hard copy documents simply because they're located in the same box as responsive documents. The plaintiff argued that Slack messages are most analogous to emails or text messages, and further asserted that parties are regularly required to produce the entirety of an email or text message conversation, even if portions of the document are irrelevant. Ohio Magistrate Judge Jennifer Armstrong stated, after careful consideration, I conclude that IBM's analogy to hard copy documents is an opposite. Different hard copy documents are not originally created in a single box, and their subsequent placement in the same box may be the result of sheer happenstance. By contrast, the parties do not dispute that all messages in a particular Slack channel appear in a single conversation, and that a participant in a conversation can view all of those messages at once, regardless of when they were originally sent. I therefore reject IBM's argument that each Slack message must be treated as a separate document like hard copy documents in the same box, and instead conclude that Slack messages are most comparable to text messages rather than hard copy documents. So she granted the plaintiff's motion to compel and also ordered the plaintiff to apply the same protocol regarding its Microsoft Teams messages, which it had agreed to do. So, Mary, do you think the 10 messages before and after determination for Slack conversation production by Judge Armstrong was appropriate, or does it seem arbitrary?
Well, it certainly is appropriate, but it's definitely arbitrary. It's why not 3, 5, 15? I'm aware of platforms that are able to produce and sequester single messages, a full day of messages, or the absolute full conversation of production. I hadn't heard about like 10 before, 10 after, and I think product management and some engineers probably needed to do some quick programming. So in the absence of party agreements, we'll continue to have functional design like this by judicial fiat.
Sure. That makes sense. So Tom, do you think we'll ever establish the standard definition of a document or conversation for collaboration apps like Slack and Teams, like we have emails, or will it always be subjective?
Oh, you mean the standard definition we have of what an attachment to an email is?
True.
We only been working on that 20 years.
Yeah.
Mm-hmm.
So I think the short answer is no, especially as, I mean, you mentioned Slack and Teams, by the time even if we got a definition, Microsoft would have changed Teams 10 times to include 14 other products and features, and 3 new products would have popped up. I'll go back to what I said just a moment ago. Have some flexibility in your agreement, your protocol, your exchange, however you've decided to do that, so it incorporates these sorts of issues, and you don't have to bring this up in front of the court and brief it and have this sort of argument. Try to have some foresight and work these sorts of issues out. If you know you've got text messages in your production, then try to contemplate what's going to happen with those text messages. I will say, as an aside, I do think we'll get better handling of text messages. It seems to me I read about a vendor recently who was coming up or had come up with a solution to display text messages more like emails, more sequentially like emails. I think we'll get some solutions like that from the vendor community, which will maybe more productive than doing any attempt at a definition. Just, try to decide what you're going to do when you're reaching your quote unquote agreement regarding exchanging documents.
Yeah, absolutely. Because certainly every case may be different, and you're going to have the one of the things, of course, if you've got somebody communicating in text or in Slack or Teams for 2 years and they have a discussion over a period of time that's relevant, you've got to figure out a kind of an approach to get that relevant piece without 2 years worth of irrelevant stuff. So that's certainly one of the challenges we deal with these other forms of ESI for sure. So Judge Peck, given that the defendant indicated that it had already reviewed all Slack messages and produced relevant messages within the 10 messages before and after window, would that have been enough for you, given Sedona Principle 6's assumption that responding parties are best suited to determine the techniques appropriate for their own production?
I guess it depends. First of all, it is not clear to me whether the defendant produced the surrounding 10 messages before and after, or just looked at them, decided which ones were relevant, and only produced those. In addition, and most importantly, and Craig Ball put a comment in the question box as well that led to this, or that discussed this, defendant didn't tell the court, as far as we can tell from the opinion, how much it would cost for them to redo it from the 10 before and after to the 20 before and after. And it may well be that it was, virtually no cost of slicing it that way. So it would have been better if this issue had been resolved before they did any production of that, but it wasn't.
Yeah, for sure. Craig certainly pointed out he wished the parties in court had addressed the burden, and he did provide a quote from the opinion, which was what I remembered, that the judge stated, IBM has not provided any information regarding the number of messages encompassed by Lubrizol's revised proposal or the burden and expense associated with complying with that proposal. I therefore cannot conclude that requiring IBM to produce additional Slack messages as set forth herein would be unduly burdensome on IBM or disproportionate to the needs of the case. And he puts in all caps, make a record, folks, which is certainly great advice for sure. Also, Matt Linehan points out that this case is rather timely in light of this year's upcoming amendment to Federal Rule of Evidence 106, which expands the rule of completeness. A great point. And by the way, Matt was the one who recommended to me that case involving the dispute over the deposition. So I meant to mention that earlier and forgot. And Matt also had a comment on the previous case about the requirement to preserve option to conduct pre-production review a la Judge Peck's 502D order, not require it. Any last comments before we move on to our end slide about this case? All right, I will move on then. And it's time for the contacts page, and we do have a date for our next case law webinar, which I believe Kaylee mentioned at the outset, but we'll remind you here, 4 weeks from today, June 27th at 1 p.m. So please do join us then. And until then, I will say thanks to Mary, Tom, and Judge Peck, and to our questions from the audience, our audience, for their great questions and comments. And I'll turn it back over to you, Mary, to close us out.
Thank you, Doug. And Kaylee, will you be back for resources?
Very briefly, because we are a little over time. So if you look at the paperclip on the right side of your console, click that. You can save your seat, as Doug said, for the June installation of important eDiscovery case law. We will be on our brand new On24 webinar platform, and we hope to see you there. Be sure to subscribe to eDiscovery today to keep up with your daily breaking news, and check out Doug's 2023 Internet Minute infographic. It is very cool and very insightful. And then a fabulous resource, Tom O'Connor's latest drop or book, eDiscovery for the Rest of Us. And then you can also learn how to engage with Judge Peck and just learn more about him. And then up next on EDRM's webinar channel, June 6th, a tech lawyer and an information scientist walk into a bar. They discuss ChatGPT, its promise, ethical considerations, and latest developments with Ralph Losey and Dave Lewis of Redgrave Data. And back to you, Mary.
Thanks, Kaylee. And the EDRM wants to thank Doug for anchoring, Tom O'Connor and the Honorable Judge Peck for this insightful presentation today, and our thanks to the EDRM community for your kind attention. We'll see you next time on the EDRM Global Webinar channel. Thank you.
Bye, everybody.
Thanks, everyone.
Bye all.